number 4, extension of compliance obligation to ALW2 and each LLC guarantor. Basically, that the accommodations agreement rules, the accommodations agreement and our corporation rules are binding and enforceable against each of the guarantors.
So again, I addressed that, and I thought sensibly that in reading through the handbook, I've only seen 2 places. And obviously, we were silent on your Carson Settlement comment, and we'll now bring it up. We obviously disagree. The Carson Settlement is a recorded document. It's important to every stockholder. It's important for their property rights, as are the deeds, as are what Greg Cross and Jeff Kenney recorded on the 27th of January 2015. Those 3 documents had equal weight. And if your lawyers are telling you differently, then sit with your lawyers and call any settlement attorney in Maryland and say, I'm going to buy a piece of property, and there's a recorded document in court. There's a recorded deed with a bunch of other agreements, and we've got a deposit in the HOA depository, these 3 agreements. Which one rules? And that's how you have to deal with all 3. So with regard to the rules in the handbook, we've only seen, I think there's 2 places where it speaks about the Carson Settlement without naming it incorrectly. The Carson Settlement does not say some of the property. The Facilities Disclosure Agreement says some of the property. That is inaccurate. I don't know who came up with the Facilities Disclosure Agreement, but when you do not disclose to a property buyer or a property owner rights that affect their property, it'd be one thing if the corporation didn't know about those rights, but you all obviously know about those rights. You negotiated those rights. So those have to be disclosed. We're not here to say rules are right or wrong. So we're all over 18. We all have to follow all the laws. What has been done to us during the last year has been to do, not letting us drive on the roads with our invitees or not. It's illegal under Maryland law.
Can you just move back a little bit? All of a sudden, you just froze and the sound kind of like muted. So I heard you started something saying what happened in the past year.
What happened in the past year has been policy. When the FBI told Chief Sperry this, that the Gibson Island Corporation and the police are enforcing a policy, not a law. And Chief Sperry admitted this, knowing it was being videotaped with the FBI agent Greg, Special Agent Supervising Greg Domro. So again, we've got no problem with the handbook, other than we know that there are 2 places where it misstates without naming it the Carson Settlement, but it says there was a settlement. It says when it was. Same thing in the Facilities Disclosure Agreement. I would be terrified of the Facilities Disclosure Agreement as the Gibson Island Corporation, the Gibson Island Real Estate, because you all know it exists and you know what it says. And to give a document to somebody that says exactly different than what it says, and you know about the document. So what we had to go through to get the Carson Settlement, I didn't ask, but I will. David Cordish, what he went through in 2005 to get the Carson Settlement, to be able to get into the club after we convinced him to buy a property here. I called Barbara Ann, and I was doing a deal with David Blake. He said, we can't be there because we're Jewish. I said, that's crazy. I picked up the phone in his office, called Barbara Ann. She said, of course he can, introduce him to me. He bought, and we thought everything was fine. And it wasn't until I talked to Miles recently. Miles said, oh, no, they wouldn't let him in the club. He had to invoke the Carson Settlement. I said, David Cordish went and got the Carson Settlement? So again, I appreciate your preamble, Lewis, about Carson Settlement has no bearing here. It has all the bearing in the world. I've been trying to think of a way to not bring it up. I think it's a real problem for the corporation with the way they've used it against us, with what it says and with what the handbook says and with what the Facilities Disclosure Agreement says, which are completely opposite from the Carson Settlement. So again, try to figure something out. But the reality is, as a stockholder, and all 5 of us are stockholders, you mentioned before that we're all 5 stockholders. But the Carson Settlement is very clear about the rights of stockholders. A short version was recorded by Greg and was recorded by Jeff Caney, when the clubhouse financing, 18 million bucks for the clubhouse, was done because there were some members, there's some stockholders who weren't members of the club, and people didn't want to pay those monthly fees. So the Carson settlement, without being named, was a short form recorded. And in fact, it's crystal clear in the HOA documents. Now, putting everything on the table, corporation can get 66% of the people together and change the deeds. You'll have pushback from people. They can change what was recorded in 2015. The corporation can't change the Carson settlement. Corporation has used the Carson settlement against us. All we want is the rights under the Carson settlement that we have. And again, before we ever had the Carson settlement, we were lorded to what the Carson settlement said, which were bits and pieces and not the entire Carson settlement. I've talked to Fred Hetzel from the Carson settlement. I've talked to his son, Freddie. Okay. What they went through, not quite as bad as what we've had to go through. But, they ended up choosing to leave Gibson Island. We choose not to leave Gibson Island. So again, the rights under the Carson settlement are the rights that you all have. We were shocked that, Bill, you hadn't read it, and that, Louis, you hadn't read it. We knew Patty had likely read it. She agreed she had read it because her former husband had to sign it, probably because he was on the board. But again, this is real estate. You're a real estate company. You're an HOA. You've got to follow certain rules. We're not here to tell you what's lawful, what's not lawful. We all know what's lawful, and we can all do what's lawful. But when a police officer takes her vehicle and swerves it at us 30 feet away, and we have to call Anne Arundel County Police, who finally started behaving after we called the county executive, and the new police chief was in. I mean, what's been done to us is beyond what should have been done to anybody.
Don't worry, I'm not going to get upset.
I'm sorry, I couldn't hear.
I said, don't worry, I'm not going to get upset. Move on.
I don't know where that leaves us or leaves you on section 4. Respectfully, our advice, and we obviously disagree that is to the applicability of the Carson agreement here. We do not believe it comes to bear on a potential accommodations agreement for a commercial business on Gibson Island. I don't know if you want to move on from section 4 and say that you disagree.
Louis, I'm not saying that the entity, which is group home, under the Carson settlement, has the right to give their stock to human beings. So there's a case which was presented by your lawyer in Maryland that says, no, the Carson settlement has to be human beings. We are 5 human beings. I can walk into the club and order a cheeseburger. I haven't done that because that's going to upset people. But under the Carson settlement, I have the right to do that because I am a human being stockholder, and that's what the Carson settlement says. It also says, as a stockholder, I can do that in 2015 that Greg Cross and Jeff Candy reported. So that is a fact. So the Carson settlement comes into play because if Jeanette's not here and she wants to order to-go meals, someone's got to pick up the phone. If Hunter's not here, I can pick up the phone and order to-go meals. I never have sat and hung out at the clubhouse. Been there maybe once or twice, in any given year. We're not drinkers, so not going to the bar and sitting there. But those things exist. To get letters threatening to throw Jeanette out of the club when I go get ice, or when we walk down to the beach because it's rented to the club, Carson settlement is very clear. Carson settlement is also very clear what the lease says, and the lease does say it about the club discriminating against the aged and against the disabled and against a lot of other people. So the Carson settlement's important because it takes care of the club discriminating against anybody. That was part of the point. The club is being used to discriminate against people. That's why the corporation and the club agreed to what they agreed to. Corporation agreed to the Carson settlement. The club agreed to, in putting in their lease, that we will not discriminate, including the aged and disabled. So it's important, not because the entity of group home, which is an entity, has rights under the Carson settlement. It has rights because it can designate people stockholders. Carson settlement can give all that stock to me, and I'm a stockholder again. I'm already a stockholder. I can pick up the phone and call the club and get to-go food, and the club makes money, and my guests and occupants get the food. Or I can get to-go food myself, or I can walk across the golf course. Golf course has been used for walking, Jeff and Sarah Candy walk all the time, walking dogs, jogging, playing golf. I haven't seen anybody dirt bike on it. But the Carson Settlement says it's about the youth, not club members, because the Carsons, Dr. and Mrs. Carson, Fred Hetzel were never club members. They were offered club membership in the middle of the settlement. They said, we don't want to be club members. We just want to use and have access to the property. So that's why the Carson Settlement's important. It's already recorded in the court. So again, we're happy to follow rules. You know, that's fine. But again, if a rule is illegal, or if a rule is being pushed against us that's not being pushed against anybody else, or a rule is all of a sudden made up, someone says you can't drive on the roads. Well,
I don't think that's in play here. What we're saying, and again, I will, our legal advice that we have received is that for the purposes of a potential accommodations agreement, the Carson agreement is not relevant. I was really trying to get back to section 4, where we're trying to make each of the individual guarantors that they will become a signatory to the accommodations agreement. That's all this section is. If you object to it, we will move on.
No, whoever's going to sign it, I'm fine. Whoever we decide ultimately will sign it, I'm fine with them being a signatory.
I'm sorry, what?
Whoever's going to sign the agreement, I'm fine with them being signatories.
Did you catch that, Patty? Bill, I'm sorry, you're just freezing up a little bit, and I just want to make sure that we have it both so we can hear it and that the recording captures it.
What I heard, Craig, is you're fine for anyone to sign the agreement who you agree should sign the agreement.
Right. So right now, what we were, is that better? I tried to switch to a different. Is that better connection?
We hear you.
And
Yeah, we have no video with you.
Hang on.
I have video still.
You have video now? Is it any better?
I've never lost video.
I
Somewhat.
see video, but you weren't, your mouth
Yeah,
isn't.
you're kind of frozen there.
Now you're moving.
Okay.
Yep.
Now
Right.
we got.
Is that okay now?
Yep.
Yep.
All right. So right now it's Jeanette and myself. You really want me for the group home, sole member, assisted living well, 2 sole member. You want Jeanette because she's going to be running the day-to-day. And then Lucy Family Trust, all those entities would in fact sign, is what we're proposing. We understand you all are proposing that you want more entities signing. I'm the sole member of all those entities, so you're just getting my signature redundantly.
This is something I think, during that the lawyers can, between your lawyers and our lawyers, that they will hash out together.